So thank you all for joining us today for this current state of healthcare privacy event. I'm so happy to put this event together and to get some brilliant speakers to talk on this topic. And thank you to our state bar for sponsoring this event. My name is Tony Granova. I'm an associate at Baker Hostetler. I'm also a member of our privacy and technology section, EC, as well as our IPP, local knowledge net. So definitely been putting together some awesome events this past couple of years, hopefully more. So if you're interested in speaking on a topic of expertise, let me know. The cool thing about this section is we have brilliant people in a diverse area of practice, and privacy kind of trickles down into everything. So yeah, I'll let our awesome speakers kick off with intros. Destiny, I'll let you start off.
Hello, I'm Destiny Kelly. I work at Change Healthcare. I've been here about 4 years now. So far at Change Healthcare, I've worked on business associate agreements, incident response, individual rights management, and privacy by design.
Hi, I'm Brittany Jones. I am Associate General Counsel and Privacy Officer for Dispatch Health. My intro to privacy was through the State Health Benefit Plan at the Georgia Department of Community Health. But in my current role, I work on all things privacy and a bunch of other corporate, regulatory, and healthcare matters.
Awesome. Anna Spencer, I'm a partner at DLA Piper. I'm based here in Atlanta. Before that, I was at Sidley Austin for many years in Washington, D.C., so have always focused on regulatory matters. I'm highly specialized. I focus my work in the healthcare industry, and I work with a broad range of companies, so healthcare providers, health information technology companies, vendors, that, any sort of vendor that processes health information, health plans, and I counsel on a wide range of issues. A big part of my practice is regulatory counseling. I also, in all sorts of areas related to data privacy, security, and electronic exchange of health information. So I counsel on HIPAA, high-tech, state health information privacy laws. Also, I'm doing a fair amount of work on the new information blocking rules that were put out by ONC. I do some transactional work, some data breach preparedness and response, and I also do a fair amount of legislative or lobbying work, although I'm not technically a lobbyist anymore. I used to be.
All right, so without further ado, Brittany, can you please kick us off with an introduction to the current legal landscape of healthcare privacy in the United States?
So, when you think of healthcare privacy, the major legislation I think that comes to mind are HIPAA and high-tech. With HIPAA, we have the security and privacy rules that are going to impose the technical safeguards, risk management, auditing, monitoring of EPHI, and the privacy rule is going to apply to electronic, paper, and oral protected health information. When high-tech was passed, it was passed to basically expand HIPAA compliance and require providers that had breaches to report specific information to the patients and the government in certain instances. And it also provided patients with access to certain information of their own healthcare information in specific timeframes. The FTC requires and enforces the health breach notification rule, which applies to entities that are not covered entities or business associates that are required to comply with HIPAA. And it is kind of not exactly analogous, but similar to the HIPAA requirements. So essentially, consumers can get notice regarding breaches of their sensitive data. FTC is also going to be the agency that enforces health apps, those types of devices, and they have to comply with the breach notification rule as well.
So that's a great picture from that, from our federal perspective as well as our agency perspective. Curious about how states are handling health data at this moment.
So in the US, it's an evolving and emerging area of state law regulation. I would say, Europe may be a bit further along than we are with doing at least a concerted data privacy framework. California is one of the states where we've heard a lot about privacy regulations, the CCPA, and the updated CPRA regulations are going to come online on January 1st. But in California, health information that's de-identified under HIPAA and derived from PHI is going to be exempt. And on January 1st, 2023, the exemption for employee personal information that currently exists is going to go away. And so you could have a covered entity in California whose PHI is exempted from CCPA, but they must comply with CCPA for other types of data that they have, like their employee data. So for those California employees, they have all of the rights afforded to them under CCPA regarding their data. In Virginia, they have the Consumer Data Protection Act, which has a carve out for protected health information under HIPAA. But it also contains an inference that the entity itself is the carve out rather than the type of data, which is what we have in California. So it's not just the fact that you're a covered entity. The PHI is the data that's carved out under CCPA, and the other types of data the covered entity processes is not. It's subject to CCPA, but in Virginia, their act has an inference again that all of the data that's processed by the covered entity and potentially the business associates are exempted. Under the Colorado Privacy Act, known as the CPA, they also have a data-based exemption where the type, again, of data, the HIPAA data, is exempted from regulation under the CPA. In Utah, they have both data-specific and entity-level exemptions. And then in Connecticut, they have certain entities exempted entirely, which include covered entities under HIPAA.
Patchwork legislation gives me heartburn. I don't know about y'all. I help a lot of organizations with state law compliance. And so I'm constantly looking at matrix that has definition, and then it has each state's similarities, differences, etc. And just to draw an interesting point on this state complexity, we know Colorado recently released the updated draft regulations. And I want to note something within the definition of revealing data. So it mentioned how an organization that mentions geolocation data, which shows an individual visited a reproductive health clinic and is used to indicate an individual's health condition or sex life, is considered sensitive data. And so this is just really interesting. We constantly have new definitions, new carve-outs. We have sensitive personal information inferences. And so organizations have all these different items to consider. And so just tying that in with all this Roe v. Wade chat, Anna, what's your perspective, especially with your background from these legislations being developed and legislations prior? Just wanted your thoughts.
Yeah, so what's going on with the overturning of Roe v. Wade, the Dobbs decision, and the regulation of healthcare data? I can't overemphasize the importance of that decision. and its potential ripple effects throughout, the healthcare system and the regulation of this data. And we're seeing it in real time, but it's going to take years. I think things will be in flux for years. The initial thought was, okay, we want to protect the health data of women who are seeking abortions, and put aside for a moment, our everyone's personal views on abortion, but just looking strictly at the regulation of health data. The concern is, of course, well, now health data, for really the first time ever in a very broad way, might be sought by law enforcement and used to prosecute women. So the first few weeks there was discussion, of course, about, well, does HIPAA protect the data? That's our federal health information. As we were talking about, that's our primary federal law. And the short answer there is no. It wasn't drafted for that. It was passed in the mid 90s, and the final rules were in 2000. So there are lots of exceptions under HIPAA. HIPAA says you generally have to keep the information confidential, but there's a litany of exceptions that can be used by law enforcement. 3 in particular. There's the exception for disclosures required by law. And in some states, you have to report, for example, crimes on premises. So query whether prosecutors will use that to demand information. There's an exception for law enforcement inquiries that generally requires a court order, but assuming you have a court order, you're either under the required by law exception or the law enforcement exception, both of which allow the information to be shared. And then there's another exception for disclosures necessary to avert a serious health or safety issue. And so the quick answer was, okay, HIPAA's not going to do it. So now what we're seeing is states try to fill the gap, and also for companies to be a little bit more proactive and try to lock the data down. We've seen some announcements by Google and others to say we're really going to take care and put safeguards in place to prevent the release of the data. And we're seeing states like California. California recently enacted 2 laws, one that applies to telecom companies that are based in California, that say the telecoms do not have to cooperate with out-of-state warrants. So if a telecom gets a warrant, normally they would cough that data up, no problem. But if it's an out-of-state warrant and it has to do with abortion, they have the right under this law to not cooperate. However, that's going to be litigated, because you've got, one state telling a company, you can't release, and then another state saying you have to release. That's going to end up in litigation. So we don't know how that's going to work. The other state law in California is one that applies to healthcare providers and employers and vendors of those entities that may have access to this data. And that law says they may not release the data in response to a subpoena. So that certainly fills that gap that HIPAA left. I'm sure it'll be litigated as well, but that's what we're seeing. So it's a lot of moving parts right now. And under the CCPA or the California law, I still think that that's pretty limited protection, because it's not specific to this issue. And those laws, there are exemptions for health data, and there are also carve-outs or exceptions for meeting legal requirements, both of which would probably allow for the disclosure of the data to law enforcement.
Yeah, I also think it's interesting because you start to see just companies almost like a self-regulation ripple effect. And like you said, like with Google, how they're coming out with just automatically deleting location history now. And Flow launching the anonymous mode.
Yeah.
So it's interesting to see organizations just in the private sector increase and just build in privacy by design, or build in stronger privacy measures.
Good question for the audience. What are your thoughts on, self-regulation that we're seeing by these organizations versus regulatory regulation? I ask that because there are some people who believe that, there shouldn't be so much regulation because regulation is burdensome, believe it or not. So just quick thoughts. Are you pro this self-regulation? Or are you like, no, we need something more set in stone and formal? And I'm gonna point you out only because I've heard you speak brilliantly a plethora of times.
Right. So I'm a general counsel for a software company here in Atlanta that our clients are ambulatory surgery centers and hospitals. And our software stores all this awesome EMR data and administrative data. We host it with cloud product. So I'm worried about this like every day. I'm worried about it while I'm sitting here. Hoping I'm not going to get hacked. Yeah. I think I have a challenge because we're VC backed. I've got insurance concerns. I've got people who are telling me we don't want to spend any more money than we have to. And so I don't want to spend any more money than the law makes me spend. So actually, from my perspective, regulations kind of help me, that I can say, no, guys, I know this sounds absurd to you that we have to do it, but it's the law. So that's my pitch for why regulation kind of has a good place for it, where you might have a nonprofit hospital that may say from an ethical, moral perspective, and I don't have shareholders that that I have to make this argument to, why do I have to spend one more dollar than I need to? Anybody disagree? Do I get to pick on somebody?
I'd also like to add a +1 in the column for regulation because with the proliferation of technology and AI, like there's just copious amounts of data out there. So even if, there's de-identified data from a HIPAA perspective that's out there, someone could get a different data set that has nothing to do with your healthcare and marry them together and then have all of this personal health information about you. And I don't believe that with the financial pressures that businesses have, that it will self-regulate in that area. And I think that's as big a risk as the actual PHI getting out there.
I agree. I think the only real answer from a legal perspective, because you can always, if law enforcement can force a warrant, it doesn't matter if it's encrypted, or if it doesn't matter if it's on a platform where the company has said we generally don't like this. So I think California's approach of passing specific laws through their legislature to protect the data is really the only way to truly offer protection.
So before we segue from the legal landscape into actual technologies regulated, just wanted to pause for any questions, comments, or concerns to our speakers. Anna, we can jump right into digital health.
Okay.
What is digital health? Tell us about that. And so mind you, in this segment, we're going to talk about digital health, we'll talk about telehealth, and we'll also talk about those full health apps that we all have. But kicking off with digital health and how the regulatory area impacts this area.
Yeah, so with digital health, we need to be careful to define our terms, because different, people use that term differently. It really can be everything from a personal app that someone uses to track their symptoms. It can be also something that actually is used there's a prescription for, and it's regulated by the FDA, and it's providing healthcare. It can be something that is available only through prescription, not regulated as a medical device, like software is a medical device, or SaMD. So you could really have this wide range of types of digital apps. And how they're subject or how they're regulated really depends on a number of factors. The type of app is certainly one of the factors, but also who's using it and how it's being used. So certainly if a HIPAA covered entity offers the app and makes it available to their patients, that's going to be HIPAA covered, right? If a mobile app developer, let's say, makes the app available as a service to a HIPAA covered entity, then that entity is going to be a business associate and regulated by HIPAA. In contrast, we can have, so that's a covered entity offering or a business associate. We can also have apps where covered entities and business associates aren't involved at all. It's really just direct to consumer, and there's no role of a HIPAA entity. And in that situation, it's going to be outside of HIPAA, but that doesn't mean it's not regulated. It is still regulated. It's just regulated under, for example, the FTC Act. So, Section 5 of the FTC Act allows the FTC to take action against unfair, deceptive trade practices. And so the FTC is active in this area. There's already been a settlement with Flow Healthcare, which many of you are probably familiar with. That was under Section 5. So the law here, the regulation here really depends on the type of app, how it's utilized. There are many different types of apps. I didn't mention or make clear that increasingly, this is good, I think, in healthcare, these digital health apps have been sort of rejected by payers. Historically, they wouldn't reimburse for them, but that's changing. And just like this last week, Highmark, which is a huge commercial payer, said that they were going to cover somewhere around 10 digital health apps. And so that's exciting. I think it's the right result, because as we saw from COVID, treating people where they are is really where medicine is headed. So I think that where we start to see more and more reimbursement by a health plan, then if the medical app or digital health app developer can bill for the care to a payer, then the digital health app is going to itself become a HIPAA covered entity. So those are three types or four types, depending on how you slice it up. And the regulatory implications are how HIPAA applies and the other regulations that apply to the processing of personal information or health information really depend on the facts.
Love how you carried us into the segue of telehealth, because that's right where we're going to jump into. So you can kick us off with the same thoughts on telehealth and the privacy considerations that we have around this, as well as the regulatory area impacting telehealth per se. Well, how does it impact telehealth?
So even prior to the pandemic, we had somewhat of a focus of trying to treat people at home, at work, if in certain situations. But the pandemic exacerbated a lot of that. My employer is a in-home mobile healthcare provider, and the pandemic did wonders for our business. And there's been a push towards telehealth, but before the pandemic, there really wasn't. The regulators weren't really on board with a wholesale adoption of telehealth across the board. But the public health emergency related to COVID kind of ushered in a new wave of telehealth, and I don't think we can claw it back. But so telehealth is basically called sometimes telemedicine, and it's the delivery of health services through electronic channels. So it can be audio only, can be audio and video, can be asynchronous, which is like store and forward, could be a one-way data transmission, or a combination. Some in-home medical providers use what's called remote monitoring technology as well, which helps your provider to, monitor your vital signs and get that transmission in real time and intervene if necessary. So what are the risks with telehealth? So of course, with using any sort of platform, communication platform, whether it be the remote monitoring or audio, video, there's going to be the transmission of PHI. And so those vendors will become business associates of the provider. And so as a provider, you have to really vet those vendors because they're acting on your behalf. And if they breach PHI, while your business associate agreement, you can, go after them. Ultimately, as the covered entity, you bear the ultimate responsibility for that data. So another risk, I think, around remaining HIPAA compliant with various telehealth platforms is that what your HIPAA compliance looks like is going to vary based on the type of communication that you use. So you are really going to need to think through what types of technology you use, whether it's voice over IP, landlines, cellular networks, or Wi-Fi networks. And I would also really consider some of that from the patient perspective, because I don't think it's necessarily intuitive that all of these other entities will receive and process your data in a telehealth perspective, because most people are just like, I'm talking to my doctor, and they view it as being in that room and it's just you and the provider. But ultimately, even if your business associate breaches the data, that reputational harm is most likely going to be felt by the provider. So I would really think about a lot of that when implementing various telehealth technologies. And also with remote monitoring technology, there are a lot of folks that are tech focused venturing over into healthcare, and they haven't had to think about data in the same way. Since healthcare is highly regulated, I've come across some companies that are really up to snuff on the tech pieces, but don't really understand from a privacy perspective what they can and cannot do with the healthcare data. And so, you really have to dig in and ask questions about what they are going to do with that data. I've come across some business associate agreements where a remote monitoring company, technology company is saying that, they want to be able to de-identify the data. And, I'll think about something like a heart rate, well, what is left after you de-identify it? So what is it really that you're going to do with the data? And it's like, am I not understanding what you're trying to do, or do you not understand how to de-identify the data and what regulations apply to the data? So to ensure your telehealth platforms are performing and up to par and are HIPAA compliant, you should really engage in a lot of auditing and monitoring activities. The business associate agreement is great, but if you aren't really testing those vendors and ensuring that they're engaging with their own security standards and technical aspects of that, you won't really know. I've seen a lot of like privacy and security attestations that, you know, some payers will send out. That's one thing to consider, but also on-site audits may be warranted in some situations. And the one other piece about telehealth I wanted to highlight before we transition is around audio only. HHS has recently released some guidance on how to remain HIPAA compliant if you use audio only telehealth. And that guidance, basically, you should consult it if you continue to use it after the public health emergency expires in January. Is when we're expecting it to expire.
You brought up so many good points. Like right when you mentioned the agreements, I was thinking, gone are the days where you give an agreement and you trust that everyone is doing what they're supposed to do. Especially in the day of everybody and their mama is de-identifying data. Like, how are you doing it? Say you're doing it, like, you know, what exactly is happening? And you look like you had something to say during.
I had a very narrow question to ask in terms of assessing your vendors. Have you seen a lot of them instead of saying, go ahead and audit me, to turn over a high trust certification?
Yes.
Like what percentage are you seeing of that? Like a few of them or a lot of them or half of them?
I would say at least half have high trust. I've come across several that, you know, will want to turn over their SOC 2 reports, and particularly when you start talking about offshoring of data. But I can't really say for sure percentage-wise, but most, I think, I'm comfortable with saying most will probably have high trust certification. And they present that, of course, as a proxy, but we also retain the right to engage in audits, even if they are high trust certified.
Any additional points on that?
No, I think the de-identification point is interesting. I mean, there's two ways to de-identify under HIPAA. There's the safe harbor and the statistician method. And one thing that's interesting, and an interesting current development in healthcare regulatory privacy, is that de-identification by safe harbor is really under attack. I mean, there's this, it's very widespread, and there's been a lot of media companies that have called it out as not being adequate. And so companies who are buying and selling this data not infrequently find themselves in Stat or, you know, New York Times. And so to be able to, you know, defend yourself, you really have to give a hard look at that practice now. It used to be that didn't used to be the case, but right now I would say that that's not by any means. I mean, it's never been risk-free, but there are particular reputational risks now with the safe harbor that did not exist before.
But I would say that it really depends on what you're going to do with that de-identified data. So for example, in our company, we de-identify so that we can do testing. But we could just as well use an entire client's database to do that, but they're all afraid of me, so they said that de-identify.
Well, this is a little different. What's been criticized in the news is taking information, like say you're a vendor, and then de-identifying the data and selling it.
Yes.
And, you know, and leveraging it in ways that maybe the covered entity didn't fully anticipate or authorize. That, like, I think I don't know if this is what you're describing, but the internal use of de-identified data, no problem. but it's where you commercialize or monetize it. And that is where there's been a lot of heat on some companies and no OCR action to my knowledge, but I think at some point they're going to catch on and there's going to be a lot more scrutiny there.
So I've gotten pushback from some of our clients who say, even if you de-identify, the regs say you may not de-identify because that's an unpermitted use, period, other than to provide us services.
But okay.
But, you know, and I first read the regs, but, you know, and
Yeah.
you kind of say, well, I sort of see where they're leaning, but you've got to, the regs aren't perfectly written, and that's not how ultimately, I can't win with a client, right? I either want to sign a contract with them or I don't.
So let's touch quickly on health apps. I know that since the pandemic, we've seen an increase in the use of health applications, and most of these developers and organizations do not fit the traditional threshold of a covered entity. So Anna, I'm just curious as to how we handle these compliance gaps for these organizations that are not a covered entity or traditionally a business associate. Is it just a wild west for them? Like, what happens?
Well, you know, I was saying before that the FTC, Section 5 of the FTC Act applies. And while there are no regs in this particular situation, there are enforcement actions. So look at the Flow Health. Flow Health is an app that helps women track their fertility. And the allegation was that even though in their privacy policies they had said, oh, you know, we're going to keep this data really confidential. It turns out that they were disclosing data to Google Analytics and Facebook and all these tech companies, and they were not by contract for, you know, limiting the further use by those companies. And so the FTC comes in and says, wait a minute, you have to abide by your privacy notice. So if you know you say you're not sharing the data, then and you are, that's an unfair or deceptive trade practice. And so looking at, or if you have a vendor and you don't lock down what they're able to do with that data, that can be a violation of Section 5. So, you know, looking at these enforcement actions, I think, is really what you have to do in the absence of regulations. And then you do have to, you know, and it's not just Section 5. Brittany mentioned the health breach notification rule. If it's a personal health record or a personal health record vendor, an entity that pulls data from a personal health record, then you've got that. You've got the breach notification rule, and there are regs under that rule. So that's helpful. But it's important to remember also that the FTC is really going to be active in this area. They've said that. They've said under the personal health record, this health breach notification rule, that they consider a wide swath of applications to be personal health record vendors, which we didn't always think of. You know, this is not intuitive. Like what we think, I think the average person thinks of a personal health record is something that aggregates health information from a lot of different places and then allows the consumer to decide where the health data goes. That is not the FTC's view of a personal health record. A personal health record, in their view, is something that, you know, you can enter data yourself. It's an app that allows you to track your own data. You're not pulling it from necessarily anywhere else, but it's aggregating, in their view, if it's pulling your location data or other information on the phone. That's a pretty, we didn't consider those to be personal health records before, but the FTC does now. And even scarier, they've said they are going to consider as a data breach sharing of health information in ways that are not authorized by the individual. Well, now, wait a minute. We thought breaches were hackings, stolen records, unencrypted, you know, data being sent unencrypted to an unauthorized third party. No. FTC says that in their mind, a data breach is any sharing that would be unauthorized, even if it went to a vendor. So, the health apps in this space need to be scared and they need to pay attention to what the FTC is doing. I expect a lot of legal actions because the argument has been by a lot of folks is that the FTC doesn't have this authority. They would like this authority, but neither Section 5 nor HITECH, which is the legal source of the authority for the health breach notification rule, really clearly support what I'm articulating, this broader view of their enforcement authority. So whoever gets tagged, the first, out of gate after this recent announcement of their authority, I would expect that they try to block that, or they try to challenge it.
Well, that's amazing. So it sounds like there is some oversight there, and these developers should definitely be concerned about the FTC and Section 5. Great point. So, we've talked about different ways the data is being collected, whether it's through these digital health apps, or even telehealth. And I'm sure there's so much more that we're not even considering, and there's so much more to come as well. The next question comes around, what happens after this data leaves the hand of the user? When it's collected, how is it being used and processed behind the scenes? Think about secondary uses and misuses. We constantly see headlines of fines of organizations leveraging data for secondary purposes, but informing users. So Destiny, just usher us into a chat about data ethics and why it matters. How does an organization ensure that data is being collected, processed, and used ethically?
So from a literal perspective, data ethics is just the moral obligations that are associated with how data is being used. It's when you think about data ethics, it's a very introspective question for organizations. And I think it goes hand in hand with privacy by design. And you just have to, it's just really important because you have to look at, okay, if we're using the information this way, under the assumption that it's permissible, that we have consent, should we be using it this way? So just really asking that question when you're considering data ethics. And when it comes to privacy by design, just weaving that into how products are built. And it goes back to the questions you mentioned, Brittany, and I think you might have mentioned it too, Anna. Just when you're working, if there's another use that a product team is considering, okay, what are you doing with that? Why? And just going through your privacy impact assessments to see, should we be doing this? Because ultimately, it could impact your bottom line. It could have, reputational harm. And that's just important. That can be tough to recover from. So those are some of the things I can.
No, great point. And Brittany, I know you had a point about, the secondary uses of data and healthcare data being merged and leveraged in different ways. And you had highlighted Amazon's attempted acquisition of One Medical. Could you add some more color to that conversation?
Sure. So for those of you who may not know, recently Amazon is to acquire One Medical, which is a primary care practice. Their goal is essentially to, excuse me, to let their members have more of their time back. So you're not sitting in the office, waiting 2 hours past your appointment to be seen. It's very efficient. And so Amazon acquired or is in the process of trying to acquire One Medical. Some regulators are looking at it. And it kind of just set off a bunch of alarm bells for people because Amazon doesn't have the best track record around privacy with their other devices. Alexa has been alleged to record in your home. You don't necessarily know that it's happening. The Ring doorbells, they're recording and they pass that information on to law enforcement pretty regularly. and easily. Excuse me. So there's, a concern with Amazon having this information and, coupling your health data or using your healthcare data along with all this other data that they have about all of us, and using it for monetary gain or even to, market different products to you. There's also an issue around opting in or providing consent for them to use your healthcare data, and a risk that you don't know that that's what you're necessarily consenting to. If the consent is presented to you in such a way that, you think, okay, well, I'm gonna click this to get this discount on my Prime membership, not realizing that in the finer details, you've consented to the One Medical arm of Amazon, then using your PHI for all of these other things that you don't even realize that you're opting into. And there's also some hesitancy about the acquisition, because the current CEO of One Medical is not a physician. And so there have been questions around whether or not Amazon will endeavor to always have a physician running, with the thought being that their ethical obligations will provide a bit more cover for the patients regarding their privacy.
And just to circle back to what you mentioned, just about the fine print, I think that's another, just once you collect data, at the point of collection, you become a data steward, which also plays into data ethics. But transparency is just really important in, using that plain language, so that consumers can, it goes back to the informed consent principle, right? But I think all of that just goes together, the consent, the transparency, and organizations just maintaining that trust, that starts when someone provides you with their data, and when you become a data steward and not like destroying that. So
It seems like the states are trying to address this through dark patterns, the ways of collecting consent and providing notice to users. These are really interesting points that you bring up. So before we dive into our last point, which is HIPAA outdated? I'm just curious. We've talked about so many different compliance thresholds. From existing PIAs that have been conducted as it relates to consent received for a certain processing. Okay. And then we also have future state, January 2023, we have California and Virginia kicking off. Then July, we have another set of states. And then December, we have another state. So how do we balance current requirements with future states in, selling our organization on privacy? There's a lot of juggling that's happening here. What do you suggest for councils? Coffee? Wine downs after 5?
yeah. I think it can be interesting to balance, but when you look at it from a perspective of, I think what states are doing that's helpful is at least addressing PHI, so information that's already covered under HIPAA, whether it's from the perspective of if you're an organization, like a business associate or a covered entity, or if it's just based on narrowed down to data type, like protected health information. There's some type of way that that's being addressed in regulations. So that helps because you get to set that perspective of your business aside. I think where it becomes tricky to balance is like with CPRA, with employee data now coming into play, or B2B, data coming into play, and that was formerly under CCPA carved out. Just managing that, for the most part, it seems like most state regulations that are emerging have similar, at least at a threshold, similar requirements. There's some that are more stringent than others, but I think, I guess my advice to council would be know what data you have, have really good data maps. Just start, if you don't already have that in place, just start figuring out what do we have, where is it going, what are we doing with it? What was, what are our rights associated with it? What purpose was it collected for? So that at least when you're looking at your organization or new things are coming through, you can segregate like, okay, these areas of our business is where we need to primarily be concerned about CPRA, or this will still live under HIPAA, et cetera, almost like data tax. Additional points?
Yeah, I mean, I definitely think this is an area where you have to invest. You have to invest resources. You have to, yes, this is the time and maybe our economy is headed in the wrong direction, but, it can be, if you don't invest in data privacy and security, it's going to cost you. So I think this is an area, we're talking about ethics, data governance. You have to have the people, processes, and, umbrella objectives and principles that govern all of this. Otherwise, I think particularly for companies, I mean, you can maybe distinguish between companies that are not directly data companies. Some companies want to be data companies and their entire business is built around data. And so for companies like that, you really have to have a major function. You have to be following this closely, and not just following it, but like you have to be trying to influence it too, probably. So other companies that depend on data, and there's arguments that have been made about every company now is a data company. I don't necessarily believe that, but if your whole business is not based on the processing of personal or health data, maybe you can not have as much of an investment, but otherwise you have to invest and you have to follow this really closely. Now, my hope is that the best thing about these state laws is that they're putting pressure on the federal government to create finally, federal health and personal information privacy laws. And I think eventually we'll get there, because what's happening now is totally untenable. Businesses cannot do business this way.
Seriously.
This is ridiculous. So I think ultimately we'll get there sooner, not in this session, but perhaps in future sessions.
Alrighty. So in light of all that we've discussed, we've talked about where the states are at, we've talked about federal agencies, we talked about new technologies, updated technologies. Is HIPAA outdated? The question of the evening. First, our audience, show of hands. Is HIPAA outdated? No? Okay. Okay. And I was looking for the and I had brought up a great point about that. I didn't think there'd be but business wise, there could be a reason to argue, hey, leave it as is. Yeah. So would you like to kick off the discussion first?
Sure. Because you just talked about how we have now what we consider traditional healthcare data, but now we've got these health apps that didn't fall under the definition of healthcare data because a healthcare provider didn't enter the data or collect the data. The patient's collecting the data. We have the parallel things happening with the FDA, who says, this is a medical device. Oh, we just changed our mind because it's really a health app, but so we're sort of not gonna regulate it.
And they just changed that again last week. Now they are going to regulate it.
Oh, bummer.
Yeah.
Really? That sucks. Tell you why later. We have this blending of information that we didn't have before, and HIPAA doesn't cover that. That's the problem. And it doesn't recognize these other technologies. It's supposed to be technology agnostic, but it raises too many issues. Okay, who wants to dispute that?
Are the HIPAA exceptions narrowly construed?
No,
The courts know.
I mean, in terms of, do you mean like the application within
The law enforcement allows various exceptions.
those are interpreted generally broadly.
Oh, broadly, okay.
Yeah.
So that doesn't protect the.
No.
individual.
Right.
Well, I'll say,
Any additional thoughts from the crowd first?
Yeah.
Any additional thoughts? No? No? Okay, go ahead.
I'll just add to counter that, I think HIPAA's doing a good job for what it's intended, right? So for protected health information, I think it's great. It's certainly not a comprehensive, data protection law. I think something could emerge on a federal level that's like a cousin to HIPAA to cover personal information that falls outside of PHI. That would be fantastic. That's not what's happening right now. So it's challenging to operationalize, but it's happening.
Yeah.
But I think just for what it was intended, PHI, yes, it's great, even from a individual perspective, and even if your client's an organization, it protects it well.
I think it's a brilliant piece of, and I don't say that about much federal law. Like, I think it's brilliant in part because it is the opposite of CCPA. CCPA, we have proposed regs that are 75 pages long. That is ridiculous. That's a European style type of regulation. I don't like it. I represent businesses. Okay. Maybe as a consumer, I would like some protection, but HIPAA is general. It carves out things so the healthcare industry can move along day to day, and it requires greater protections for things like marketing and sale of our data, which we expect. I think it's very workable. I think it's a great statute, but there's a gap as a consumer. Okay, yes, I would like to see something covering these direct to consumer purely outside of HIPAA apps for sure. It's why I don't use them. I mean, I'm a privacy attorney. I would never download a health app that's not subject to HIPAA because I'm concerned about that. Now, maybe there are companies coming along that are saying we want to really invest in the protection of data, and I think that I will be quickly revisiting that. But there's also a counter argument that HIPAA goes too far, and I will just articulate that. And there's some good arguments, and they are what HIPAA has led to is data silo. And we don't need data silo. Like, the healthcare problems in our country are so big with, disparate care, with quality, public health. We need to be able to unlock the value of this data, and we can't do it under HIPAA because it's all siloed. And healthcare organizations, when they get these requests for public health and other purposes, they're like, heck no, that's a problem. In Europe, they have a single health system, and so there's a record on every, a fulsome record on every citizen that can be tapped into and is tapped into. And what I don't like about our differences here is that in the UK, they can do cooler and faster and more efficient stuff with data, and they're beating us. Countries like that are beating us. I don't like being beat. I want access to that data. And right now we can't do that. So I would say HIPAA needs to change, but not in the ways that maybe everybody would want to see. Not to be stricter, but actually be looser in some situations.
Very interesting. Go on ahead.
Anna, do you think the information blocking regs are opening in the direction you're talking about?
Yeah, I love that. It's a great question. So, the Office for National Coordinator of Health IT under the 21st Century Cures Act, we now, and everybody's going to know about this because you're all going to be doing it. The rules say that healthcare providers cannot block an individual's access to electronic, it's EHI, electronic health information, not PHI, but EHI. And what that means is that you get to download your own consumer app, and you get to send a signal, an API, to all healthcare providers, and they have to, by law, give you your data, respond electronically. And the idea is that ultimately we're all going to have these apps, just like we're able to bank. You know, I have a great banking app and I use it all the time. And it's easy and I love it. And we should have that for healthcare data. We don't. But because of that law, and that was so hard fought, I helped, I worked on that too. That's going to revolutionize healthcare data management and analysis in this country, because think about that. We're going to be able to control our own health information and aggregate it. It's exciting. It's real exciting.
But do you think it takes away from no doctor will ever be able to be on his or her own practice or have a small practice, because the cost of doing that is very, very high.
Some would argue that an API, implementing an API, it's standard technology. That should not be that expensive. That's part of the reason they went that direction, is because it's supposed to be automated and standard based and secure. Now, as we all know in healthcare, pretty much any technology can be hacked or compromised, but it's a trade-off. Like we want to liberate that data, and there are trade-offs there. In terms of the expense, I'm not the best to speak to that. I mean, I would love healthcare providers' insight on that. I know that as part of the reg, because federal lawmaking requires that you estimate the costs to stakeholders. I don't know what those were, but I'm sure there is a cost, but it shouldn't be. At least once the companies, it takes some time for companies to realize the opportunity. But I'm seeing companies really flock to this space. And so I think that at least there'll be the companies, the vendors that will help healthcare providers, offer this.
Good point. I'm just thinking this must be the same API that will send the GPC requests. All these APIs sending signals related to requests. Do we have any more additional questions before we wrap up?
Since I'm not here, I have no basis to be able to say anything, and I apologize. I'm just curious about who should be making these decisions. I know in a jury trial, which is sort of the fabric of our country, you'll take 9 people off the street, and they'll get it right just about every time. But if you look at the people that are getting digital technology credits, about 25% of the people graduate with those types of degrees. If you double it to another 10%, say 10% knows what's inside a box. Well, that means you're excluding the other 90% from even participating. They don't even know what it means. That didn't used to be a big deal until digital technology came along with concepts of dynamics and scalability. And for people to think that I can figure out what's going on with 5,000 questions at one time, and I can do it with the speed of light, that makes no sense to them. But if you could get them to the point where they truly understood, then they could start participating, take over the role of a business analyst and develop algorithms. If I wanted to get GPS numbers for people in this room that traveled, I could figure out when you're going to the hospital, what you're from, and I could, using predictive analytics, come up and say, you're pregnant, you're not pregnant, you've got some type of cancer. I could use all types of current strategies and methodologies, put them into an algorithm, I can come up with a decision. That's 5 to 10% of the people that only have a clue that that's even possible. So I'm raising the question, should you grow it? Or do you want to just say, look, it's just going to be those who have power, those who have absolute power. That's just the direction we're going to go.
Well, the rules that she was just referenced, the interoperability and the information blocking, that destroys or helps destroy what you're talking about.
It helps, but people don't understand the concepts of what can happen today. It's one thing to go back to the way I was using my mom and neighbors had ideas, but now you're doing stuff that's just weird.
Yeah, but what you're talking about, I think, is right now, this data flows. So like FTC, this was years ago, they did a study on mobile medical apps where's the data go? And on average, I think they found that like the data goes to 17 different companies that the individual, to your point, has no idea was happening. But when you control, but what two, I guess two things. When FTC says and starts enforcing on with 30, 40, 60-year enforcement actions against health apps that say if you don't follow your privacy practices, like locks that down. So I do think that that helps, like the enforcement that's happened. And so I think that sharing is somewhat changed. And then when an individual controls, you know, it's one thing for a business to control, but when an individual controls their own records, and now the technology is such that just like with mobile, the banking app, it's all happening on my phone. It's not, you know, it is the bulk of the processing happens here, and this is in my hand. So like that, you know, I do think there are some trends that are helping the individual, the average individual,
Participate.
and control. There, you know, big business would not, you know, a lot of what you're talking about, I think, in terms of losing control of your data is counteracted with policies like we're talking about. It's pro consumer.
This is sort of the first time in the history of humankind that somebody says, you want to be, and you just make it up. I want to be this, I want to be this, I want to be this. I want to be a rock, I want to be that. Well, in the past, people have said, that's unrealistic. You just can't do that. Now digital technology has enough ability to appeal to human senses to think that I can do what I want to do the rest of my life. Somebody's going to control that type of thing. So it's a real paradigm shift that we're moving into, and most people aren't capable because you can't do that. You can't take data and you tell me that I'm sick today. I mean, you just can't, and you can't.
Really interesting points here. Really interesting points. I mean, we're going to see over the next couple of years and going into the next decade, good gracious, you know, it's going to be a whole lot of data. It's going to be a whole lot of, I just think about, I don't know if y'all have seen the movie Looper, the rainmaker, you know, who sits at the top and is making all the decisions. But anywho, thank you all for coming out tonight. And if there are no additional questions, we can all literally just move over to the reception together. Because I know like the folks are out there waiting. So I don't want to keep them waiting. But thank you all. Thank you all.